Good morning, everybody, and welcome to September's employment coffee briefing. I hope those of you who've had an opportunity to have time off in August had a good break and are ready to get back into what is bound to be a very busy end of the year with the new government and all of the changes that we've discussed in the past that might be happening over the next few months. This is moving actually now towards the end of this first series of these briefings. We said we were doing the employee life cycle over the course of the first year or so, and we're just about there. I think we're almost a year since the last one, since the first one. So the last few sessions that we're dealing with now, we're getting into dismissals, we're getting into settlement of legal claims, and we're getting into post-termination issues over the next 2 or 3 sessions. After that, I'm then happy moving into next year to start taking suggestions if there's anything that people want covered in more detail, or if there's things we haven't talked about that you might be interested in us doing a session on, and we'll see how it goes from there. Otherwise, I will just pick a topic each month and talk about it for 45 minutes to an hour and see what happens. But today, we're still on the employee life cycle and we're talking about the end of it. We're looking at dismissals and tribunal claims that might arise in dismissal situations. As always, the session is being recorded. It'll be made available to all of you afterwards, along with the briefing note that follows up. And it's also then made available on YouTube and via the Friends website. As always, I've got access to the Q&A, I've got access to the chat box, so as we go through, please do feel free to ask any questions as and when they arise. I'll do my best to answer them, but again, as always, I will spend most of today's session just talking through the topic. So, dismissals and tribunal claims arising on dismissal. Like I often start with, the legal framework we're interested in today is primarily the Employment Rights Act 96. That's what sets out a fair dismissal and the claim for an unfair dismissal. And we will also be talking to an extent about more general contract law principles, well, for the simple reason that we're talking about an employment contract. So in a little bit more detail, today's session and an outline of what I'm intending to cover. I'll start with what amounts to a fair or arguably unfair, depending on which angle you want to approach it from, dismissal. Looking at that both from a factual perspective and also the procedural measures that we need to apply to make sure that we are dismissing in fair ways, if indeed we are dismissing. Bulk of the session is going to then turn to constructive dismissals, because that's an area that we've not touched on at all yet in these sessions. They are not uncommon claims, but they're also not the most common, but I think it's worth being aware of them and understanding A, how they arise, and then B, some of the situations in which they arise. And then towards the end of the session, merging those last 2 bullet points, we'll talk through what the actual legal claim of unfair dismissal looks like, how the tribunal tends to approach them, and we'll also talk about what is to an extent the fairly limited value of them, but also how that can be mitigated by you as employer or by the client, the employer clients you have got, for those of you who are HR professionals. So where should we start? Let's start with what a dismissal actually is. One thing I will keep coming back to today is thinking about the employment relationship as a contractual one. I've said more to follow because it becomes a lot more relevant during the section on constructive dismissals, but I will start with a brief overview now. And it is true that ultimately we have an employment contract, we call it an employment contract, and it is fundamentally a very regulated contractual relationship between employee and employer. I will pay you to do work, you will do work in exchange for pay. Second part of it is ultimately when I tell you to do work, you will do it, and I am obliged as the employer to give you an opportunity to work. That is inherently the test of what an employee is. So what is a dismissal then? Well, a dismissal is a clear ending of that contractual relationship. It is a termination of a contract in exactly the same way as we might terminate a contract with our phone provider or a builder or anybody else who in your day-to-day or commercial life you may form a contract with. The big difference, as we'll come on to in more detail, is the law tells us the circumstances in which we can terminate this type of contract. That termination, as I said at bullet point 3 there, could be actual, So that is going to be your decision as the employer to terminate, perhaps in gross misconduct or as a redundancy. It is going to be the employee's decision to terminate. So that will be a resignation, an ordinary resignation, or perhaps a resignation that ties in with retirement. Or, second point, a dismissal can be constructive. It can be inferred, it can be implied from the circumstances. Strictly speaking of those two, the dismissal is an action taken by you. A resignation ordinarily isn't actually a dismissal in law. A dismissal is, strictly speaking, the action taken by you as the employer. But from a lay point of view, obviously, we also do tend to think about resignations as potentially being dismissals. But yeah, from a legal point of view, be aware that a dismissal is, strictly speaking, your termination of the contract as the employer. I've also mentioned service requirements at this point because I think it's an important one to come on to early. Ordinarily and currently, in order to bring an ordinary unfair dismissal claim, an employee, and does have to be an employee, requires 2 years service, requires 2 years continuous service with either the same employer or connected linked employers. Now, the reason I say ordinarily in the introduction to that is there are types of dismissal which do not have a service requirement. If you terminate in a situation where, for example, an individual has blown the whistle and you terminate them for making that protected disclosure, that's an automatic unfair dismissal. They've had that right despite not having 2 years service. Similar rights and similar abilities apply, for example, if the employee is asserting some other statutory entitlement. Dismissals in relation to things like maternity are automatically unfair and obviously also potentially a form of discrimination. And they do not require that 2 year service under current law. The reason I say currently, of course, going back to the session before last, I believe, is, of course, we've got the Labour government telling us that they might reduce the service requirements for unfair dismissal. Some of us will remember it being 1 year before it went up to 2. As we know, Labour are potentially talking about bringing this right back to being a day 1 right. I suspect we're going to get more information of that later in the autumn, probably sometime around the budget, which I think is intended to be towards the end of October now. Watch this space, basically, because some of what we say today, for now, assume that it is the 2 year service requirement, but if they do reduce that service requirement and introduce unfair dismissal as a day 1 right, there is every risk that everything we're talking about today is something you will need to be aware of from the moment somebody is employed. So with that covered, let's move on to talk about factual fairness. So the first thing we want to do, of course, when we're looking at fairness is make sure we've actually established a reason. As I was saying earlier, we've got this established contractual relationship which exists, and then we've got statutory law telling us the circumstances in which we are allowed to terminate somebody's employment. And these are the ones that are set out in the Employment Rights Act. Between about sections 90 and 96 is where you will find all of this stuff in relation to unfair dismissal. The right is in there, as well as this list of potentially fair reasons. So they are in order: conduct. I'm not going to talk about conduct in any significant detail because, of course, we did an entire session on gross misconduct investigations, disciplinaries, and termination in those circumstances. So feel free to go back and watch that one again if you desperately want to hear my voice for another hour. Ditto capability, of course, we did a session on capability and performance. So again, if you want to listen to me for another 2 hours, you can listen to both of those again on the back of this session. And indeed, I'm not going to make the same joke 3 times. We've also done a session on redundancy and how you establish a fair redundancy in law. As we know, all 3 of those require some kind of process, some kind of investigative or consultation exercise, and they have fairly limited definitions, particularly, of course, of redundancy. The other 2 that we are allowed under the Employment Rights Act are illegality stroke statutory restriction and some other substantial reason. I'll spend a little bit more time on both of those because we haven't already done a session on either of them. So illegality or statutory restriction is the Employment Rights Act recognising that there are situations where it may become unlawful to have somebody employed in the role in which you employ them, and therefore it should be reasonable to terminate that individual's employment. A couple of situations where that might come up, for example, you employ somebody primarily as a driver and the legal restrictions around what vehicles they can or can't drive change, or potentially, although I'd maybe want to combine this with some other substantial reason, they lose their driving licence. It would be unlawful at that point to employ that individual as a driver and allow them to undertake the role for which they are employed. So you have potentially got an illegality argument there. Other forms of statutory restriction, if the job the individual is employed for becomes regulated, particularly if it becomes regulated under statute and they are not compliant with their regulators' impositions. I think in our profession, for example, I couldn't be employed as a solicitor if I was no longer on the roll. But then that is potentially a statutory restriction. It's unlawful to practice as a solicitor if you are not qualified to be, and that could give an illegality statutory restriction dismissal. The place where I think it has most commonly come up in the last few years was towards the middle end of where we were having the biggest deal, I suppose, around COVID and lockdown situations. And many of you, particularly those working in that sector, will remember that in the care sector, very briefly, we had that law brought in that said basically everybody who works in a care home has to be vaccinated. Now, whether we agree with that law or not, whether it was in breach of potentially human rights, whether it was a lawful statute or a statutory instrument to bring in the first place, is beside the point. Employers at that time did rely on the fact that anybody who wasn't vaccinated could not be lawfully employed in that role. And there were a lot of dismissals that were based on that, as people will be aware. I know we've got pending cases just, on a central hearing as to whether that was ever acceptable or not. Many of you will have been involved in consultations and dismissal processes at the time. I, on balance, think it is probably a defence. We don't have to agree with the law in order to follow it. It is what the law said, albeit for a very, very short period. So my view is that that would have given an illegality defence. But as I say, we are probably going to be waiting years for the Supreme Court to tell us that. The final reason out of those lists is some other substantial reason. It's often described as a mop-up provision, which is pretty accurate, really. What it's basically there for is for an employer to be able to say, we couldn't establish one of the other four, but look, we've got a really good reason why we can't continue to employ this individual. I've given a few examples there. So I've used reputational risk. That is potentially one that is likely to fall under the definition of some other substantial reason. So the employee does something either in the workplace or even potentially outside of it, which damages the employer's reputation, wider business reputation is what we're driving at here. That could potentially give you a reason to terminate. Breakdown of trust we'll come on to in a little bit more detail later, because in effect it's the reverse of a constructive dismissal, or certainly the most commonly cited constructive dismissal claim. And we'll often see that one tacked in at the end of a disciplinary letter. So again, those of you who draft those fairly often will know that you will often go through a disciplinary letter where you're concluding a dismissal, and the words breakdown of trust or our trust in you has deteriorated, something like that will appear at the end. That does allow in the tribunal for you to in effect argue both, or argue some other substantial reason as an alternative. If the tribunal concludes that the misconduct argument wasn't successfully upheld, you might lose the summary dismissal element. You might not lose the overall unfair dismissal, because you've also got the breakdown of trust as some other substantial reason. I've also included expiry of a fixed term contract at that point. That's a slightly trickier one to rely on, because obviously we've also got fixed term contract regulations and the various provisions around those. But in principle, a contract does end at the end of its fixed term. That said, when you're relying on an employment situation and the individual has got more than 2 years service, I think you're looking at expiry of a fixed term contract plus. there is going to be some need to say that not only have we reached the end of the contract, but also there is no longer a need for this individual to do this work. So there will be an element of overlap there, I think, almost with a quasi-redundancy situation. I've been asked a question as to whether expiry of a visa falls under illegality or SOSR. Yeah, it is potentially illegality. I think you'd probably argue both to be on the safe side. I think the primary dismissal is going to be it has become unlawful to employ you, and that may well be true on expiry of a visa. In terms of your some other substantial reason, you could probably also say you're actually in breach of your contractual obligation to have the right to work in the UK, and then that becomes your SOSR on top of it. Unless anybody's got a different view on that, feel free to share it, or any extended question from that. I'll just pause for a moment in case anybody's got anything they want to say on that point or any of the 5 that I've raised there. Okay, if not, I'll come back to questions at the end, as always. So yeah, as I've said at the bottom there, the basic principle in the tribunal as well here, and it's useful to know, is you're the employer, you're the one who's terminated the relationship. The default is you need to be the one to prove that one of these applies. The first 3, maybe 4, are more common. We're generally on safer ground with understanding how they work. Some other substantial reason, a lot of employment lawyers in particular will say to you, try not to rely on that as the primary reason. And the justification for that is simply when we get to tribunal, we are allowed to argue in the alternative. We are allowed to say, look, even if we didn't satisfy capability, even if we didn't satisfy illegality, we've got some other substantial reason here. And the most useful place that arises is in a conduct dismissal. You will have terminated on gross misconduct in summary. You're dismissed without notice. It's the only one of those where you can. So if you're then able to separately argue some other substantial reason, as I was saying when I was talking about it a moment ago, you may well have dismissed for gross misconduct and incorrectly terminated without notice. The employee might then get their notice paid back, but at least we haven't got a continuing loss because the some other substantial reason may have been a fair dismissal. So that all the employee has actually lost then is their notice period, and we're not talking about the extended awards for the unfair dismissal in the first place. So moving on, we have potentially established our reason, and like I say, go back to conduct, capability, redundancy for those. Illegality and SOSR are more rare in my experience. Most lawyers don't like relying on them, and like I say, most HR practitioners are involved at a point where it's going to be conduct, capability or redundancy more so. So having established the factual reason, and let's assume we have done so, the tribunal also considers substantive fairness. The ultimate test that the tribunal is reaching here is, has the employer satisfied itself that redundancy in all of the circumstances was fair and reasonable? So again, in relation to conduct, in relation to capability, and in relation to redundancy dismissals, I've talked about fairness and process and procedure for those. That's the investigation, that's the consultation exercise, bearing in mind the consultation and redundancy might be a statutory one. It's the opportunity for the employee to present their version of events, and it is the opportunity for the final hearing and all of those things that we'll come on to be taken into account before reaching a decision. The entire UK legal system is pretty much propped up on 2 words, fairness and reasonableness. And they equally apply here as they do in so many other areas and jurisdictions. So when we're talking about fairness, when we're talking about reasonableness in relation to a dismissal, we're talking about that in relation to the process itself. If you're going through a conduct dismissal, of course, you've got the ACAS code of conduct to follow. If you're going through a redundancy, you may have a statutory process you should be following. Beyond those, you're also looking at all of these other things as well, and they are all potentially relevant factors. Have you adapted the process to suit the circumstances because you may need to for some reason? How thorough has your investigation been? Again, the test is what is reasonable for you as an employer in the circumstances you find yourself in. In a performance dismissal, have we given the individual opportunities to improve, and are those opportunities reasonable, measurable, attainable. You know, in performance, in capability, we are looking at smart target setting, and that is a good benchmark for identifying whether it was a fair performance process. Have we given consideration to things short of dismissal? This is one that occasionally gets missed out, and it is a question that I will always raise when acting for an employee, particularly if it's been missed from an outcome letter. Did you consider the demotion? Did you consider the final written warning? And more importantly, if you rejected those things, why? Explain it. Tell the employee in that outcome letter why you think dismissal is appropriate but a final written warning wasn't. It could be the seriousness of the offence. This could be where you start to take into account existing warnings and things like that, but show that you thought about it. And the other big one that arises is predetermination. So this is going to be your investigator asking obviously leading questions to try and get the individual to incriminate themselves. It is going to be the final decision maker coming into that disciplinary hearing with the assumption that the person is guilty. It is going to be any correspondence, and let's not forget subject access requests have made this incredibly risky, which does anything to imply that the dismissal was a done deal before the disciplinary hearing, basically. In relation to predetermination, I often point out when I'm acting for an employee, and will also do it when acting for an employer, that a decision making which takes place on the day doesn't look great. You know, if you've adjourned the disciplinary hearing for 10, 15, 20 minutes, come straight in and dismissed the individual, particularly in a situation where there might be questions for you to consider, predetermination is quite easy to at least infer in those situations. I would always challenge how well the decision maker has been able to take into account a 2-hour disciplinary hearing in making a decision in 10, 15 minutes. And the bullet point I put at the end there is sort of the benchmark you want to compare yourself against. What would be expected of a reasonable employer in your circumstances? And it's not a bad question to ask yourself, what would I expect if I was here and I was going through whatever process this may be? I'll just pick up on one question because it's connected to the previous one I answered. Is an illegality dismissal, particularly the visa case, with notice? Yes. Basically, there's not many situations where you can terminate without notice, and it is generally situations where it is clearly the employee's fault. I would say on notice is safer, but obviously there is an argument to say, one, they're already in breach of contract if your contract requires them to have the right to work. And there is an argument, of course, to say that they couldn't have worked out their notice period because it's no longer lawful to employ them. So safer on notice, but there is probably an argument that you would get away with it. Obviously, do I say this? Yes, I do. There is a difference between what should you do and what are you likely to get away with. My view would be that you pay it on notice to be absolutely on the safe side. That defeats any option for them to turn around and say, you've now breached my contract and unfairly dismissed me. People will disagree with me on that. That's the joy of employment law, as we all know. Okay, so that to me covers the basics, and as always, this is very, very high level. You know, I'm not going into a huge amount of detail on these, but that to me covers factual fairness, substantive fairness in dismissal. So I'm going to move on to constructive dismissals, unless anybody's got any burning questions on factual or substantive fairness. Right, so in order to think about constructive dismissals, and constructive dismissal, just to tick it off very quickly, the employee resigns in a situation where they were justified in doing so and basically blames you as the employer. It is usually something the employer is said to have done wrong that has caused the resignation, and the law recognises that the employee should be able to have some kind of recourse in that situation. So I've already talked about the employment relationship as a contractual one. And yes, basically it is. It's a commercial contract to do work. Over the last probably 200 years or so, and as we know, certainly in the last sort of 50, it has become a highly governed, highly regulated contract. And that is because if you look at the old language of cases, if you look at the old language of statutes, a lot of our employment rights stem from master-servant home staff, basically, relationships. That's where most of the sort of unfair dismissal principles, general treatment of staff come from. And a lot of the health and safety stuff comes from agricultural and mine workers at the end of the day. But yeah, it is ultimately a contractual relationship. So there are situations where it can be terminated both ways. We've got our situations, we've got our list of ones where we're allowed to terminate, but it is also recognised in law that the employer has a lot of power in this relationship. It's a very unbalanced contract. The employer's got the resources, it's got the money, there's a very good chance the individual wants the job more than you want the individual. So there is a huge potential for the contract to be inherently unfair in the favour of the employer. And that's why a lot of the regulation and a lot of the statutory law developed over time. So in other contractual situations, and this is the brief divergence into general contract law, you can usually terminate a contract on notice. I'm forgetting an employment contract for a moment, I'm talking about other commercial ones. Your phone contract is a prime example. You can terminate early. There is very, very likely to be a term in there that says you have to pay out the remaining period of your contract. But that will be the limit of it. It is limited in law by the terms of the contract itself to a greater or lesser extent. Obviously, this is ignoring things in relation to quality of goods and services and all of those things. We won't go that far into it. But the basic principle is most contracts you can terminate on notice without a reason. Obviously, that is very different to the employment relationship, where from our side we're saying here is a list of things that you're allowed to dismiss for. I've mentioned an SOSR dismissal, and that is functionally a constructive dismissal in reverse, which we'll come on to sort of as part of more detail in relation to how a constructive dismissal actually works. But the basic point is we've got a recognition here that it's a contractual relationship. We've already limited the employer in terms of what they can do. But because of that inherent unfairness, there are situations where an employer could potentially coerce an employee to leave in order to bypass one of those factual reasons. And that is where we've started to get constructive dismissal arise, initially as a common law concept, and then increasingly these days as a statutory law concept. So what does it actually look like? Constructive dismissal, the employee has to resign. This is where it's a constructive dismissal. Obviously, ordinarily, an employee resigns, it's a resignation, it was their choice, it was their action. That's not you taking the step to terminate, so it's not, strictly speaking, a dismissal. However, if all of these other boxes are ticked, it can be deemed to have been a dismissal and then is to all intents and purposes treated as an unfair dismissal in law. So the employee must resign within a reasonable time frame, which we'll come on to, in response to an actual or anticipated breach by the employer of a fundamental term of their contract. Those are the elements of constructive dismissal. Yes, we're going to go through them. I think the place to start, though, is fundamental or repudiatory breach. That's sort of the touch point of this. The employer has to have done something that is inherently wrong in relation to the contract. So the definition of a repudiatory breach is a breach that is at the heart of the contract. It's a fundamental principle. So it could be an express term. You unilaterally change an employee's salary, particularly if you reduce it. That is probably going to be considered a fundamental breach. What the person gets paid is pretty inherent to an employment contract. You unilaterally demote them, you change their hours, you unreasonably send them to work halfway across the country without notice. They are all likely to be express terms of the contract. If you breach those, the employee may consider them to be a repudiatory breach. It can also be an implied term, and the most common one that is relied on is the duty of trust and confidence. An implied term in contract law is one that either statute or the courts say exists, even if it's not written there. So you will not have a provision in your contract that says we have a mutual relationship of trust and confidence. It'd be very weird if you do, but the law tells us it's there. You should be able to trust your employees to act in your best interests, and similarly, the employee should be able to rely on you to treat them with a degree of trust and confidence. And there it is. The duty of trust and confidence requires employers and employees not to conduct themselves without reasonable and proper cause in a manner calculated or likely to destroy the relationship. That is a useful bit of case law from quite a while ago now, actually, but it is also a helpful definition. Both parties have this obligation not to conduct themselves in a way that would damage the relationship. So that's what potentially gives you most of your SOSR dismissals. It might not be conduct, it might not be capability, but they may have acted in a way that otherwise damages the relationship, and it gives you constructive dismissal the other way around. You do something that damages the relationship, the employee resigns, they are allowed to claim. Few examples of potential breaches of trust and confidence. You often see bullying and both discriminatory or non-discriminatory conducts. Particularly, the argument is often that the employer has allowed this to happen and I resigned in response. Breaches of process, false allegations, trying to change terms or pressure to do so. That sort of generic failure to adequately support me, that will sometimes qualify if the employee can justify it. And as I said there, both unjustified reductions in pay and benefits, and indeed in case law, deliberate and unjustified refusal to increase pay or benefits can be used. That is a difficult one for an employee to prove. You're not obliged to increase their pay or benefits, but somebody may bring that argument in a situation where they are now doing work that is of substantially more value than what you're paying them for. Other people may have received incremental increases and they haven't for no apparent reason. It could give rise, particularly if they've raised a grievance, particularly if that's been handled badly, to a trust and confidence argument. The employee then has to resign in response, so they can't wait 6 months, basically. It's very clear in law that it must be in response to the breach, and that deals with two things. Firstly, it's got to be pretty quick. You know, you can't wait and go, oh, I resigned because you didn't deal with my grievance 18 months ago. That's not in response. And it must be the reason for the resignation, which actually gives employers often a get out clause to say, well, look, actually, no, you resigned because you were moving halfway across the country and that was already planned. You resigned because you were planning to retire next year anyway and you told us you wanted to spend more time with your family. The biggest problem, therefore, with a constructive dismissal claim for an employee, and this obviously does count in our favour to an extent, firstly, they've got to justify it, and secondly, they inherently have to make themselves unemployed and then pursue a legal claim. And I think those are the two big reasons why these are so rare in isolation. It's a massive problem for a claimant. We have to breach first because we have to resign, so we have to terminate the contract ourselves as a claimant, and then justify it and say I was entitled to resign in this situation whilst, as I say, being unemployed. And I mean that before I come on to, you obviously just saw that flick to value there quickly. I mean, before I come on to anything else, that is only, again, very whistle stop of constructive dismissal. The kind of things you want to be on the lookout for are where employees start talking about the reduction of trust, the reduction of confidence. If you're getting a series of grievances, if you're getting a grievance in response to how a grievance is being handled, those are the things that are starting to look like a constructive dismissal claim. They are reasonably easy to mitigate by at least following some kind of process and behaving in some kind of reasonable way. The most successful constructive dismissal claims are one where there has been a clear and obvious breach, either of an express term or where it is a situation where it is obvious to everybody that that relationship of trust and confidence has significantly deteriorated. I have not been involved on either side in that many successful constructive dismissals, I have to say. They are also incredibly difficult to deal with early, and the reason for that, again, thinking about acting as a claimant lawyer, the cause of action doesn't arise until you resign. So all of those classic pre-action letters where in discrimination, you'll get a claimant's lawyer writing to you saying, this thing was said to my client, we consider it to be race harassment, therefore you must settle the disputes. In a constructive dismissal claim, if you get that too early, my client is being mistreated, is considering resigning, and that may give rise to a constructive dismissal, then you've got an option as an employer of calling that bluff, saying, well, okay, resign then bring your claim, knowing it's going to put the individual in a difficult position. The claim isn't there yet. The claim isn't there until they resign. So I think while they're useful to be aware of, I think they're very rarely brought in isolation in my experience, and they are often quite difficult to run all the way to tribunal as a claimant. simply because you've got those two hurdles at the start, prove the conduct was seriously sufficient and that you resigned in response to it. That's before we even get onto the question of whether there has been a dismissal, and then the question of whether it was a fair one. If you've got somebody who may be brewing for a constructive dismissal as well, it's always worth in the background just being mindful of other reasons that you might have considered terminating them anyway. You'll often get the process is something like capability proceedings, lodge a grievance about the capability process, that's not happy with the grievance outcome, resign, claim constructive dismissal. If you can show that you would have terminated on performance grounds anyway, which we'll come on to, then you're going to mitigate the risk of that constructive dismissal claim anyway. Right, anything else on constructive dismissal? Because I appreciate I've basically waffled about the word contract and fundamental terms quite a lot, but I'm hoping I've made sense. If not, again, throw a question out. I have seen the question that's come in. I'll deal with it at the end because I've moved on quite away from what that topic is actually covering. Right, so we get all the way through and we have an unfair dismissal, and annoyingly we have lost for some reason. What is the employee likely to receive? This is where I said at the start that unfair dismissal claims are often relatively low value, and it's because in comparison to a discrimination claim, they are. Discrimination claims, as we know, are rewarded on the basis of injury to feelings. They're rewarded on how badly the individual feels. And in current law, that award is in theory uncapped. The employee can claim both for that sort of psychological damage to them and resulting financial losses. Discrimination claims, frankly, tend to be the more valuable ones. For almost any form of unfair dismissal, we are limited to two basic elements. The first one is the basic award, which is exactly the same calculation as the statutory redundancy. So that is the week's pay capped at currently £700, multiplier based on their age, multiplied by length of service. The current maximum for the basic award is exactly the same, obviously, as it is for statutory redundancy. I think it's about 20 grand. It is not a huge award in and of itself. Obviously, the less service the individual has got, the less value that might be. The basic award for someone who's been with you for 4 years and is under the age of about 42 is going to be sort of £2,500–3,000. The compensatory element is then awarded in addition to that. That is up to 52 weeks pay, strictly speaking, a year, subject to those same caps, or an overall maximum cap of 115,000, 115,000. Yes, when that figure came out, we were all quite happy that it was an easy to remember number. And that comprises, in effect, financial losses arising from the unfair dismissal. It's a loss of earnings figure. So realistically, what the tribunal award in this situation is how long would this person reasonably take to find alternative employment. It is designed to reflect loss of earnings. If you get to tribunal or just before then, it will often be calculated in two slightly different ways. The loss from termination to calculation date, and then the loss from calculation to tribunal, potentially beyond that if you're very lucky and you've managed to get a tribunal hearing within 12 months. And that's basically it. So an unfair dismissal claim for someone who's only been employed for sort of 4 or 5 years and finds alternative work relatively quickly could be, £2,500, £3,000, £4,000, £5,000. It may not be a significant loss, and it is fairly common as a claimant lawyer to be advising that what they get in tribunal net, don't forget there are associated costs of running a tribunal claim, could well be less than their expenses. And it is, obviously, when you're acting for a claimant, it's horrible advice to have to give, but it is the case that unfair dismissal claims are simply a statutory contract claim to all intents and purposes. They are what is the loss caused by this unacceptable breach of the contract. So yeah, not particularly high value. That said, at the complete opposite end of the spectrum, if you've got someone who's been employed for sort of 20 years and is on a relatively high salary, you are looking at a potential 6-figure claim in theory. So as I said, I've just said it, the purpose of compensation is similar to a contract claim. What has the individual actually lost? And it is primarily their loss of earnings, benefits, pension, those sorts of things. And that is the calculation that the tribunal will sit and do. So the question becomes, what can we do as an employer to mitigate that and reduce it? Well, there is a duty on the employee to try and mitigate that loss themselves. The tribunal will not consider this unless you as the respondent bring it up. They will mention it, it's there in the case management orders, and employees will often get it included in the information packs that they get for the preliminary hearing and list of issues. There'll be a line that says the employee is to provide any sort of benefits they've received, any new paid employment. That all plays into it. But actually the argument that you want to make as an employer is stronger than that. You know, if you've got an employee who you know is going to start arguing, I've got 6, 7, 8, 9 months of loss, then be proactive in this, start preempting it. From the moment you know an unfair dismissal claim is likely, 2, 3, 4, 5, 6 times a month, find a job that you think they could have applied for. Because one of the most satisfying things as a respondent lawyer when you reach this point is the tribunal goes, okay, we've got an unfair dismissal, we're going to make an award, we think we've got 9 months loss, that's £30,000. And then you get to go, well, okay, here's a job, did you apply for that? Here's a job, did you apply for that, etc., etc., etc. And that will, providing the judge thinks those jobs are things that the claimant could and should have applied for and may have got, potentially reduce that award. And it is one of the easiest ways to bring that award down, is for you to demonstrate that the employee has failed to take reasonable steps to mitigate their resulting loss. So it is a useful exercise. I often advise it to respondents facing an unfair dismissal claim. Less useful, of course, in a discrimination claim, because the employee is probably going to argue that they were so traumatised by the acts of discrimination that they weren't mentally or physically well enough to apply for jobs. But in a normal unfair dismissal, absolutely do it. It's useful to have in a pack when we get to sort of the award stage of tribunal. Other potential elements of compensation, of course, in an unfair dismissal or other situation where an ACAS code applies in relation to disciplinaries is where it most often crops up, but you might find it in a constructive dismissal for failure to follow their grievance procedures code of practice correctly. The tribunal can award an uplift for up to 25% for failure to comply with the code of practice. It works both ways. If you don't follow the minimum standards for a misconduct dismissal, the tribunal can award by up to 25% to the claimant. On the other hand, if the claimant has resigned in a situation where they are claiming constructive dismissal and they've not raised a grievance about the issue, or they've not complied on their side with what they're supposed to do under code of practice, in theory, their award can be reduced by up to 25%. It does happen. Second one there we've got as, it's usually seen more in civil claims, but it does crop up in employment jurisdiction. Was the claimant partly responsible for their own dismissal? It's akin to that classic road traffic accidents is the best example, and you know the insurers will sit there and go, who was what percentage most responsible for this, so who's paying what amount? It's a little bit like that. So the tribunal may conclude that a dismissal was unfair, but the claimant was still partly responsible in the actions that followed through. So a claimant might resign before the end of a disciplinary process. You might find that they have successfully constructively resigned because of something else, but they could have been responsible for their own dismissal because they still did something wrong. There is still something they've done that was breach of their contract. They took an action they didn't have to take, they did something they shouldn't have done. They may still be partly at fault. The last one there is a broadly similar term. It is really last bite really for an employer. It's a historic case called Polkey. Those of you who've been through tribunal claims with us or any other firm of solicitors may well be familiar with this. It is another way of potentially reducing the compensation awarded to a claimant in an unfair dismissal. And it's particularly common in the example I've given there. If the dismissal is procedurally unfair because we haven't followed process correctly, then you as the employer are absolutely entitled to say to the tribunal, look, Polkey case back here, what it says is, could I have terminated fairly in the next couple of months, for example? Yes. Well, therefore, the claim value should be limited to those 2 months, because even though I've terminated in July, I could have legitimately dismissed in September. Therefore, we're not responsible for the losses after that. And it is a justifiable argument. It is one that is used occasionally quite successfully. Handful of associated claims to think about that will crop up alongside an unfair dismissal potentially. So people often confuse unfair and wrongful dismissals. Unfair dismissals are the ones we've been talking about today. We don't have a fair reason because it's not one of those 5, or the individual's been constructively dismissed, and stroke, or we haven't followed process correctly and therefore it's procedurally unfair. A wrongful dismissal is more literally a contract claim. It is we have terminated in a situation where we weren't allowed to do so. So the most common one is not paying contractual notice. That's a breach of contract potentially. It's also a wrongful dismissal if you want to bring it in the employment tribunal. You'll sometimes see them done side by side. There's not always necessarily a huge amount of value in it. An employee may also bring a separate breach of contract claim. The employment tribunal does have the jurisdiction to hear contract claims. They can also, as a claimant, separate the 2 claims and go, I'm bringing my unfair dismissal in the employment tribunal, and I'm bringing a breach of contract claim through the civil courts. That would either be the county court or the high court, depending on its value. The best reason for that is the employment tribunal in a contract claim is limited to £25,000. If an employee has a contract claim that is worth significantly more than that, there is value to them in bringing it as a separate civil claim. And it does happen. You may also find as a separate civil claim they'll bring personal injury. That's sort of the most common other civil claim. Where an employee brings a breach of contract claim, including a wrongful dismissal claim, that does give you as the employer the ability to counterclaim. So if you think you've got financial losses resulting from them, the fact that they have raised a breach of contract gives you the opportunity to respond. So an employee may say, I resigned, breach of contract, didn't get my notice period. Your counterclaim might be, well, okay, but we had to pay somebody £150 a day to come in and cover you on short-term notice. Whatever you're awarded, we want offset by this. In bringing an unfair dismissal claim, wrongful dismissal and or breach of contract, there's a very good chance an employee will also tack on other things if they think it's relevant. So working time regulations, holiday pay, pension calculations, and of course there has to be some other claim involved in order to bring things like failure to provide a written particulars. If you've not got a contract and then there's an unfair dismissal later down the line, the tribunal can award a payment simply for failure to comply with the obligation to give a written contract, but can only do so if there's some other claim in the background. Okay, that is basically it. I haven't got much more to say on dismissals today. I'm just under time, so I'll turn to the 2 questions that have already been asked first, and just see if I can cover those quickly, if I can find my mouse. So, first question that's cropped up is, talking about the visa question in the end of right to work in the UK being a potential illegality reason, changes to skilled workers earlier this year, continuing sponsorship costs employers a lot more in terms of salary. Therefore, employers could feasibly decide they can't continue to sponsor purely on that basis. It's nothing to do with the performance of the worker. Could that potential be an illegality reason? So the question, I suppose, ultimately is the employer is deciding to no longer be a sponsor. That I think is going to sit somewhere between a redundancy and some other substantial reason. The redundancy is difficult because, of course, there is still a need for the work to be done, and therefore you don't necessarily have a genuine redundancy situation. You might have to argue that we no longer require work to be done in the way that it's done. I think the problem you're always going to have here is that is ultimately your decision to end a sponsorship arrangement. So it's always going to be presented as a termination. I think you'd probably have to argue illegality on notice. I think it's one of those ones where you're going to have to take an assessment of risk. If these employees can no longer work for you, you've already terminated them. They've got no right to remain in the UK now anyway, because presumably the sponsorship or visa requirement falls on that. What are the risks of them actually bringing a claim against you in those situations? Potentially quite low. I think it's a question I'd want to take maybe more offline if that's something people want to discuss in more detail, because I think it might be very particular to things like the value of the employee's work. We've got the litigation risk that we need to take into account, but the fact that you financially cannot support the sponsor scheme anymore is probably going to be SOSR on balance, actually. Yes, I appreciate I've given 3 different answers there. It's because I'm thinking about it as I go. But I can see an SOSR argument on the basis of we can't financially operate the sponsorship scheme anymore. Second question I've had, does the employee have to have made the employer aware of a problem before resigning? Yeah, so this is a classic one that crops up in a constructive dismissal claim. I haven't mentioned it today because I appreciate I'm primarily talking to employers here. But yes, it really does help. If an employee doesn't bring up the issue in advance, there is a risk of the very first question that an employer's lawyer is going to ask in the tribunal is, well, did you tell the employer? Did they know this was a problem? Were they aware of the breach? Have you highlighted it to them in some way? There are ways around it. There are situations where it may not have been appropriate to do so. The break of trust and confidence may have been so serious that raising a grievance, for example, would have been a waste of time. But it is not a bad initial defence point. You know, you've resigned without giving us as your employer an opportunity to remedy it. That doesn't really make sense. This is something we could have fixed. So yeah, not raising a grievance isn't fatal to a constructive dismissal claim, but it doesn't help. In other sort of more fundamental breaches, it's not necessarily the case maybe that you'd be expected to do it if the employer has written to you and has said, for totally unspecified reasons, we're reducing your hourly salary by £5. That's a much more express breach. I think you'd be much more entitled to resign immediately in response to that without challenging it. That is a clear unilateral decision that's been made by the employer. But again, one argument here is that you should be attempting to resolve things before taking extreme action. It cuts both ways when you think about it from the employer's side. They have to go through a process before terminating for capability or gross misconduct. There's a suggestion that the other way around, there is an element of obligation on an employee to try and resolve it as well. So hopefully answered that one. Third question, can an employer claim costs from an employee if they bring an unsuccessful claim to the tribunal, or is that only in civil cases? The tribunal does have the power to make a costs order. It can be done, but it is in much more restricted situations than a civil claim. The tribunal's 2 main sort of methods of awarding costs are basically wasted costs, wasted preparation time. So a good example of that might be an application that never had any chance of success, so you prepare for a preliminary hearing needlessly, or it might be failure to comply with case management orders as we go through. The other situation, kind of more broadly, is where one party or the other has acted vexatiously or maliciously in either bringing the claim or the conduct of the litigation. I am racking my brains trying to think of a case I have worked on where there's been a successful cost application either way, and I cannot think of very many at all. It is just worth pointing out as well that actually in lower value civil claims, it's become increasingly rare to recover your costs as well. The only thing you're likely to get back in the small claims court is the issue fee. So yes, the tribunal does have that power. It's very, very rare. It has started to happen increasingly in the last few years over vexatious claims, but no, I very rarely tell people that they're even remotely likely to recover their costs. Any other questions from anyone? Just while you're thinking about that, I talk briefly about the next couple of sessions at the start of this one. So next one will be Wednesday the 2nd of October. We'll be looking at forms of dispute resolution and settlement. So we'll be talking about mediation, that's internal mediation as well, resolving disputes. I'll have a chat about ACAS and COP3 agreements. I'll also cover settlement agreements to an extent. I am hoping that our new head of HR services, Nathan, who many of you will know, will be joining me for that session so that he can talk about the mediation and internal stuff as well. So with any luck, you'll get to listen to somebody other than me for an hour. So yeah, that'll be the next session. As I say, after that, we've then got post-termination issues, and then we pretty much run the course of this first series of them. So if anybody does have any suggestions for future sessions, by all means reach out to me directly or to the marketing team. Otherwise, if there's no other questions, then this session and all previous sessions are available on the Fretton's YouTube page. I know this because our trainee is sat watching them at the moment, bless her. If you stick Fretton's or Coffee Break Briefing in a YouTube search, I think either me or my colleague Malcolm, who does them for insolvency, will be one of the first people to come up. But if you want a more direct link, again, please do reach out to me offline. I'm happy to send you a more direct link. You should receive them if you signed up for this section as an email anyway. Other than that, unless anybody's got any other questions, thank you all again for your time, and we will, Nathan and I will see you in October. Have a good rest of your day and have a good September.